That's it. And that's what you have at the end of the day. You have successfully made food using the remake machine. The peels, the cover buttons, press buttons, and the eyelets, all using the same machine. I hope this video has been helpful. Please give this video a thumbs up. Don't forget to subscribe and click on the notification bell when you're ready.
Right, we should try. just drop our attendance. Because they will not allow us to write the exam. Yes, so they are very strict. If we don't meet up to, I think, 60 or 5% attendance. Anytime we're entering the hall to write the exam, we will line up. They will now be checking our name to our percentage before we enter. So if you have a problem, make sure that you resolve it before that day. If it's to bribe them, go and bribe. Go and bribe. If that day comes like this, Tony, they won't answer you. So you have to just make sure you settle it. If it's not up to 65, I don't know how the person can. Jesus Christ. I didn't know.
Lawyer openly talking about bribe.
Honestly, that's exactly how I felt.
So, good evening, everyone.
Good evening, sir.
Good evening, sir.
Good evening, sir.
We are taking which group now? Group 5, isn't it?
Yes, sir.
Group 5.
Yes, sir.
Okay, that's technique.
Yes, sir.
Okay. You know, technique we divided technique into 2, didn't we?
Yes, sir.
Okay, so the first group we'll take today.
Oof.
Okay. I don't think I have your paper. The technique group 1 people, I don't think I have your paper, but go ahead.
Sir, it was sent to the platform this evening.
This evening.
Yes, sir.
Okay, I will check it on using my laptop, so you can start. How many people are presenting?
Just 3.
3 of you.
Yes, sir.
Are you all present?
Yes, sir, we are present.
Okay. Class captain, please confirm that the 3 of them are present too.
Okay, sir. I'll just call their names now. Trying to locate.
Because there is a mark for
Yes, sir. So,
attendance during presentation, unless there's an excuse.
okay, sir. So I don't know which 3 of them are in the group 1, but I have the names of all 6 of them in group 5. So maybe when I call those in the group 1, the first part of the group 5 will answer. So we have Alagwa Esther. We have Oluwaseyi Ebenezer. Anyawu Judith Chidima.
Present.
Okay, is that Blessing? Sorry,
Judith.
Anyawu. Judith, okay. Blessing Itohan Ahmed.
Yes, present.
Okay. Adebayo David Adewumi.
Present.
Okay. So I guess those are the 3 people in the first part.
Okay.
Yes,
Okay.
sir.
So we give you 30 minutes. 30 minutes. Your own topic is straightforward. It's not a hard topic. It is the second part of it that will take our time. So present in 30 minutes, please, so that we can discuss your paper.
Okay, sir. Good evening, Prof. Good evening, everyone. We actually discussed it jointly, but we separated the papers. Or we said we're going to present it together. I wouldn't know how we can then separate it now, but I will just go on.
We can't, that topic is too wide. We will lose track if we take all of it in one seminar. So if the 3 of you have chosen to speak to the first part, I have opened the paper now. Anyawu Judith Chidima is number 4.
Present, sir.
Blessing Itoa Ahmed. Are you is Blessing Itoa
I'm
Ahmed
number 3,
presenting?
sir.
Number 3, are you presenting with this group?
No,
Yes,
sir.
sir.
David is to present the first part.
Okay, on your list now, you have 1, 2, 3, 4, 5, 6. Who are the people presenting? Is number
David
1
will present.
presenting?
Yes,
I am
sir.
to
David will
present
present
part
part
1.
1.
I am to present part 1 and part 2, sir.
Okay. It's all right. Okay, present part 1. So that the meaning is that we are taking all the 6 of you together.
That's how we arranged it, sir.
Okay, are the 6 of you present?
Except for Aloga that is very sick, but she contributed immensely in the
Sir,
preparation
I
of
am
this
present,
paper.
sir. I
Oh,
am present, sir.
oh,
I'm
okay.
also present, sir. I'm part of the group and I'm present.
Oh, okay.
Okay.
Because she reported very strong
So
as
all
at
the 6 are present. Class governor, take note.
okay.
Yes, sir.
But where is Adebayo, David, Adewumi?
I'm here, sir.
Okay. Omobolaji, Abigail, Aderibigbe.
I'm here, sir.
Okay. I think Oluwaseyi Ebenezer. Oluwaseyi
Hello, sir. I'm
Ebenezer.
here, sir.
Okay, everybody is present. Okay. Present the first part. We discuss the first part before we move to second part next week.
Okay, sir. I would be taking the introduction, the part 1 and part 2. Then my colleague will take the other parts. So I will just move on to our part 1. Good evening, Prof. Good evening, class. Our topic is conflict of law, process, and technique. Our paper is divided into 7 parts. I'll be taking part 1 and part 2 accordingly. We discussed the introduction into what conflict of law is all about. Conflict of law is also known as private international law because it does not deal with the states, it deals with individuals, private persons in whatever disputes that arises between them. It has to do with it, the jurisdiction, which law to apply, and which jurisdiction, which court has jurisdiction, especially when it has a foreign element. Now, the aim is to ensure fairness and consistency. In Nigeria, because of the kind of country that we have, where we have the received English law, we have our own statutes, and we have case laws. So our conflict of law principles are determined by those factors. I'm going to move now to what conflict of law consists generally. In many legal, in a country where, for instance, they have received English laws, like in Nigeria. Sorry, I'm sorry, sir, I'm reading something. In legal systems across the world, we have different ways where how countries resolve this conflict of law. We have connecting factors, characterization, incidental questions, where a country has to determine if they can entertain the disputes that has arisen between those parties. And these are most of the issues that countries try to resolve when they want to determine if they can entertain any issue between a party. Now, we are going to talk about Nigeria specifically, where we talk about the choice of law. The courts in Nigeria, in order to determine if they can entertain a particular matter, they look at the laws. Hello, sir.
I'm hearing
Hello,
you.
class. Okay. Thank you, sir. Now, the choice of laws, this help the courts to look at the connection between the parties, is there a foreigner? If there is a foreigner, which law is more suitable to apply to bring fairness between the parties? Remember that the aim is to bring fairness and consistency. So every case is peculiar. So the court will look at which law is more applicable in such scenario that the court should apply. That is where the choice of law comes in. Okay, now for the second one is the jurisdiction. The court will, in determining if it has jurisdiction, the court will look at where did the matter occur. Okay, is it within its jurisdiction? Does the court have jurisdiction to hear this matter, or will it be more suitable if they attend to this matter in the other country, especially if they are foreigners? Okay, it happened in Nigeria. Can we entertain this matter or not? These are part of what the court looks at when the court wants to determine if the jurisdiction, the choice of jurisdiction, where the matter falls under. Also, in characterization and classification of the subject area, we look at family law, property law, torts, contracts. All these cases are very peculiar when we're trying to determine the jurisdiction. And like in Nigeria, if the person married within the act in Nigeria, what law is applicable to that person? Or if the person married a foreigner, but they did the marriage in Nigeria, the court will look at, okay, the marriage occurred in Nigeria, even though the person is a foreigner, but it happened here, the court can assume jurisdiction in such scenario. So I would leave my colleague to talk about the part 3 so that I don't dive into, because there we talked more about the connecting factors in specific cases, so that I don't talk about those cases. Thank you, sir. Thank you, class.
Okay. Our colleague,
Okay.
let's hear you.
Good evening, sir. So part 3, we're talking
Mhm.
about connecting factors in specific cases. That's
We
under
have
part 3.
we have not talked about characterization or classification. Can you give us a talk on characterization?
Characterization. Okay, that's under part 2.
That's very important.
Yes, sir. Okay, that's under part 2, the characterization. It talks about the process of characterization of classification. A conflict of laws is important because it determines how a legal issue will be categorized and which rules will apply based on the nature of the dispute. Characterization involves classifying an issue as to belonging to a specific area of law, which could be a tort law, a family law, a property law. It just talks about how the court tends to characterize a particular issue to know the area of law which it falls under. We also have the choice of jurisdiction. Determination of jurisdiction is essential for establishing which legal system has the authority to adjudicate the case. As they say, jurisdiction goes to the root of every case. In many cases, the parties may have connections to multiple jurisdictions, and the court must decide where the case should be heard to ensure a fair trial. We also talked about choice of applicable law. This choice of applicable law determines which jurisdiction's legal principles will govern a dispute. When we are talking about this, the court has to know which legal system the issue falls under. The purpose of this is to resolve the ambiguity regarding which country's legal rules should be applied to address the issue in this case, especially when the dispute has a foreign element. Now we have the connecting factors. To ascertain the applicable law, the parties involved and the facts of the case are crucial. The court, when seized with a suit, has the duty to ascertain the legal issues or applicable law to interpret the facts of the case. This may in turn lead to the problem of the choice of law, especially where the parties are not from the same jurisdiction or the events leading to the dispute occur across jurisdiction. If the case contains no foreign elements, the conflict of laws rule is irrelevant. For example, when the dispute is between two Nigerians who are both domiciled in Nigeria, there is no form of conflict of law rule, except when the issue involves a foreigner, where the court will have to characterize the case and look to know which of the court will have to know which of the rules to apply. For example, if, let's say, for example, when there is a divorce petition by the wife, and then the husband who is domiciled and resident in England, and the wife is resident in Nigeria, brings a petition for divorce. That's the husband domiciled in England and the wife in Nigeria. Thereby, when the court is faced as to the dissolution of the marriage, dissolution of the marriage, the court will have to know which of the rules to apply in relation to that. Then we will not talk about the law in relation to contract cases. Under the law of contract, the primary principle is party autonomy. That is, the court will apply the governing law agreed by contracting parties to the disputes. Where the agreement provides for the choice of court or governing law, it will be inferred that the parties intended the law applicable to that court to govern interpretation of the status. According to Ezekiel and Abudu, the presumed applicable law is the law of the habitual residence of the characteristic performer. It is usually the party.
Go back. What did you say?
According to Ekezie and Abdul, sorry for my mispronunciation then, the habitual residence of the characteristic performer, which is the presumed applicable law. It is usually the party rendering service and not the party with the obligation to pay for the performance of the terms of the agreements. Take, for instance, characteristic performance may include the seller in a contract of sale, the lender in a facility agreement, or the guarantor in a contract of guarantee.
Okay.
We come to tort cases, which is the lex loci delicti. This principle dictates the law applicable to a tortious act is that of the jurisdiction where the tort occurred. The principle ensures the legal remedies should align with the location of the wrongful act. When looking at tortious acts, the court will take the applicable law will be as follows. In the case of personal injury or wrongful deaths, the law of the country where the injury was sustained will be applicable. Secondly, in the case of damage to property, the law of the country where the property was located, damage will be applicable. Thirdly, in the case of the law, in any other case, the law of the country in which the most significant elements of the events that constitute the suit will apply. Then we looked at the case of Murphy versus Colorado Aviation, where the court to multi-state tort controversies contact approach. While in the case of Bates versus Superior Courts, where the court determine the state that has a significant relationship is qualitative and not quantitative. Then Lilydale Cooperative Limited versus Mean Canada, here the courts apply the most cheap test and not the qualitative test. The court held that the Alberto law, where the incident occurred, applied to the tort claim and not the Ontario law. Purchase happened. Then we move to succession to movable property. Succession to movable property in conflict of law refers to determining the applicable legal system when dealing with the inheritance of assets that are not fixed to a location, such as money, shares, or personal belongings. In cases of succession to movable property, which in courts generally apply the law of the deceased domicile at the time of death to govern the succession of movable property. However, conflicts may arise when different jurisdictions claim authority based on other connecting factors like residence or location of assets. Then we talked about connecting factor in succession law. The key connecting factor in succession to movable property is the domicile of the deceased at the time of death. Then we now talked about Nigerian legal approach to cross-border succession. Nigeria adopts a dual legal system influenced by both common law and customary law, which affects how succession cases are handled, especially when foreign elements are involved. Under common law principles, the law of the deceased domicile governs movable property, while immobile property is governed by the law of the location of the property, that's lex situs. In the United Kingdom, the law of the deceased domicile governs movable property, which is also similar in Nigerian common law approach. However, in contrast to the other civil law countries like France, they prioritize the deceased nationality as a connecting factor for succession to movable property. Then we talked about the nullity of marriage. In Nigeria, we make use of the Matrimonial Causes Act, which governs the nullity of marriages. However, when a foreign element is involved, Nigerian courts must apply conflict of law principles to determine which jurisdiction laws are relevant. The court will focus on factors like domicile, habitual residence, and the place of celebration of the marriage, which is lex loci celebrationis. Then we have the reasons for nullity and the rule of connecting factors. The grounds for nullity, we all know, is we have voidable marriages and void marriages. Then we have in conflict of laws, the choice of law governing nullity is influenced by key connecting factors such as 1, domicile of the parties, 2, lex loci celebrationis, and 3, habitual residence. Then determining applicable law under the Nigerian context. One is formal validity, which is the lex loci celebrationis. This covers requirements like registration, witnesses, and officiation. Second is essential validity, which is capacity, governed by the law of each party's domicile. This includes issues like age of consent, mental capacity, and freedom to marry. In the case of Okonkwo versus Okonkwo, the court had to determine whether a marriage conducted under foreign law was valid. The court applied Nigerian law to determine the capacity of the Nigerian party, while considering the foreign law for the marriage formal validity. Thus, the law of the forum is used when it comes to capacity. That's further illustration, okay. We have case studies and illustrations. Like I've talked about the Okonkwo versus Okonkwo. We talked about the nullity of a marriage conducted abroad. We have hide and hide. We all know hide and hide defines what a marriage is, especially under monogamous marriage, that's marriage under the Act. Then,
are you through?
Conflict of laws, part 4, conflict of laws processes. That's the advanced question.
No. You people, part 4, is it not under section B?
Yes. I'm now under
No. I've looked at your something. You didn't cover everything, but looks like section B is something else. Conclude.
Okay, in conclusion, I'll call on my colleague to conclude.
Okay, conclude. Whoever is concluding. Hello? I thought you
Hello.
said somebody was to conclude.
Yes, sir. Colleague of mine, the third person will be the one to do the conclusion.
Yes. The person is not on, or doesn't have the paper.
He should be
But
on.
I don't know what to say.
Okay.
Do we just leave it since
In
you have only
conclusion,
one conclusion?
yes, we have a general conclusion, which is practically which is our last page, sir.
So we should just leave it.
Seminar paper.
No, sir.
Yes. No, sir.
Okay, you want to conclude?
Yes,
Sir,
sir. Okay.
Okay.
sir, if I may ask, our part 4, 5, and 6, are we to leave it or what to deal with it next week, sir?
That's your part 4. I don't know what it is all about. Do you understand? The only other thing, the only relevant thing in your section B, I saw you discuss incidental question and time factor. Okay?
Yes, sir.
You didn't discuss RUVA. Is there anywhere where you discuss RUVA? No way, you did not discuss it. Even characterization, you didn't look at some aspect of it. But it's all right. Conclude anyhow, so that we can make our comments. Hello?
Sir, hello, sir. If I may suggest, sir, can we please just deal on the part 1, 2, and 3 today so that we can rewrite our part B?
If you want to rewrite your part B, you can do
So
that before next week.
Okay, sir. Thank you, sir. Then our conclusion and recommendation is in our part B, sir. Can we
Okay,
also
so
do that next week, sir?
you leave all of that for next week.
Thank you, sir.
Thank you, sir.
Okay, do we have comments? It's an LLM class. We are not supposed to be teaching you like LLB students. So, do we have any comment on the first 3 parts, which they call section A? No comment. Has any one of you read any basic text of a conflict of laws on this subject? Hello?
Sir, we have Agbede, sir.
Agbede, Professor Agbede, yes. I think Professor Agbede, long or short? Agbede has 2. He has the long book. He has the short one. The one that is essays.
Short, sir. 2015, sir.
Okay, that one. I don't know whether he has a chapter on the whole of technique or whatever. You don't have Okoli and what's this Ghanaian guy in the area of conflict of laws? You don't have Okoli's book.
Sir,
Okoli
no,
and
sir.
Opons.
Please, if we can have the name, we can get it and do the needful, sir.
Okoli and Opong.
And Ofong. Okay, sir.
Opong, Oppong.
Sir?
Okoli and Opong. Oppong. You ought
Okay.
to have another name here too, but here I am. Very lazy. I'm not, I keep teaching this thing every time. Put pen to paper. Na lie. Okay, it's all
Sir.
right. Yes.
Please, sir, you said Agbede has two. We didn't know. We only know of one. Can we know the year of the other one, sir?
I can't remember over now. And I don't know whether he decided to convert that one to a textbook again. The one I know he did is the one that used to be essays on conflict of laws, something like that, or themes on conflict of laws. He converted that to a textbook. And there are a number of essays he had published before that he combined together. He didn't write it in form of a textbook, but you find essays there that are very relevant to some of these. I know that he had a chapter on Rouvoir. And Rouvoir, he had a chapter on Rouvoir in that paper, in that short one. I think he didn't have a chapter on time factor, but he has an article on characterization, which he published in one of the journals of the Faculty of Law, University of Lagos. Okay?
Yes,
anyway, any English author text too will be useful in this area, because what we want you to know is just to become familiar with the technique of the subject. Okay? So
yes, sir.
we usually want to be very simple in discussing this particular topic, because it's like the live wire of the course. You don't know this topic, there's no difference between you and somebody who does not know conflict of laws. Okay?
Yes, sir.
It is often said that you normally be confronted with conflict of laws when you are least prepared for it.
Please, sir, can you please help us spell Rouvoir, sir? Please, sir.
Don't worry, when we get there, we will spell it.
Okay, sir.
Renvoi. Rouvoir. I'm sure Professor Agbede has a chapter on it, if you have his book. Anyway.
Thank you, sir.
As we have said, everything about conflict of laws is private, not public. It is a plaintiff suing a defendant. So you never get to know that there's any foreign element or any conflict of laws until it suddenly occurs in court. Because it's the same writ of summons, the same statement of claim, the same everything that you use in cases that do not have foreign element that you are going to use, even the ones that have foreign elements. And until the judge and the lawyers are confronted, they do not know that a conflict of law issues has arisen. We said that conflict of law issue will arise when a foreign element crops up in the narrative of a civil case. And we said that when that becomes the case, there can be any one of three questions needing the answers of lawyers and courts. The first one is choice of jurisdiction. Yes, I saw you people battling with the meaning of choice of jurisdiction. Choice of jurisdiction is not the same thing as what we do in legal system. Choice of jurisdiction is just propriety of venue. Why is propriety of venue important? Because you have said that the matter has only element. 2 or more states are involved. So which of the 2 or more states are you going to go to? Can you go to a neutral state that is not involved? That is the question of choice of jurisdiction. And like we have said, every country will have our own rules of choice of jurisdiction. Some country will say, don't bring any case here unless the facts occurred here. Some country will say, don't bring any case here unless the defendant resides here. Some will say, don't bring any case here unless the defendant is a national of this place. Every country will have our own requirement. It is for you, when you are going to court, to know what the choice of jurisdiction requirement of the place you want to go is, and all of that. At any rate, we usually concentrate on choice of jurisdiction in the second semester. So that's not what we are discussing in this class. It's just for you to know that that's a question that will arise if the matter has only element. Then the next question is what we call choice of law. Choice of law. Every dispute will have a governing law. To have a governing law that the court will apply. Why governing law? Because the case has one element, more than one country is involved, and each of the countries involved has its own law. You might find that the law of state A is different from the law of state B. So you cannot say, and this is where a person who has expertise in this subject area is different from somebody who does not have it. You will not say that because you are in Nigeria, the action has been filed in Nigeria. If the case has a foreign element, you still have to determine applicable law. You will not say, because the case is going on in Nigeria, you want to apply Nigerian law. In 90% of the cases, those who are not knowledgeable in this area, that's what they will do. But if you know this area very well, you will know that you still have to tackle the question of governing law or applicable law. Okay? That is what we are treating in this class. How does the court arrive at the applicable law? Does the court just say, look, this is volume Z, the law of volume Z will apply? There is no rule, you will not have any rule invariably that if you are litigating in state Z, the law of state Z must apply. In a way, the law of state Z will apply, but what will apply in the law of state Z is its conflict rules. So every country would have, for purpose of conflict of laws, will have 2 sets of laws. It will have our own internal law, which will regulate the subject matter in circumstances where all the parties are connected with her. Then it will have our own conflict rules, which will guide the court at arriving at applicable law, which it will then apply to the case if the matter has foreign elements. So what we are doing in this class is how do Nigerian and common law courts arrive at applicable law? In other words, what is their conflict rules in the matter? What is the technique of arriving at the governing law of a dispute that has foreign elements? Okay? So the presenters talked about characterization. What is characterization or classification? You want to look at the issues arising from the case and put them under a particular legal category of law. It's not going to be difficult for a lawyer to understand classification because we don't do law 1, law 2. We do law of contract, we do sale of goods, we do hire purchase, we do partnership, we do company law. We learn our law on a subject by subject basis. And that helps us to know when the substantive law governing a dispute, where it falls. So when you as a lawyer, you are writing a brief or whatever, you will know whether this dispute relates to land law or whether it relates to contract or whether it relates to tort. Each of those subjects are categories or classes. So when we say classification or characterization, you are looking at the disputes, the issues thrown up in the case that has one element, and you are placing them under any of those categories. Okay? So that's what we mean by characterization. Okay? Why do you have to characterize? Again, a conflict of law person will know that you have to characterize because there is something you call connecting factors. Connecting factors. And those connecting factors are not the same. They are not the same for every subject area. Okay? So when you tell a person who is not aware of this area to discuss choice of law, you see him trying to discuss everything at once. It's not, but it's not a question that anybody in conflict of laws can ask you. He will have to ask you to discuss conflict of tort laws, or conflict of contract laws, or conflict of property law, okay? Conflict of marriage laws, conflict of succession laws, conflict of, the reason being that connecting factor depends on the subject category into which a dispute falls. So that is the technique. From characterization, you move to connecting factor. You cannot arrive at the appropriate connecting factor without first categorizing the issue. Okay? So once you have characterized the issue and you know the subject head under which the issues fall, it becomes very easy for you to identify the relevant connecting factor. And we usually use from Martin Magri. Let's notice a victory. Let's notice a victory commission. Let's go with okay. So at this level, we just give a summary. We just give a summary of some of the connecting factors. Okay. I saw that the writers attempted to do that. Let me see. They did a lot of work on looking at the different connecting factors. Okay. You can read them on that too. Read their part 3 very well. Okay? But what we normally do is to give example, not go into detail here, because no matter how much you try, you can't cover the field in this one part. As a matter of fact, that is what the
Hello, sir. We can't hear you anymore, sir. We can't hear you, sir.
I think it's the network. Class rep, hello, class rep. You might need to please assist us to notify the lecturer that we can't hear him. Thank you.
Hello, everyone. Please, let's just exercise a little patience. He's having some network issues. I've reached out to him. He will get back on shortly. Thank you.
I'll take your WhatsApp, but you're not online. Yeah, I'm not online. Okay. As what? I said with you or what happened? $18,000. Which one is 18? It's 18,000 naira now. See, 18,026.88. That's what they collected. I'm the one that sent it to you now. I sent to you as text message.
Mute yourself. We're hearing your conversation.
It will be in your account, say, when you check. Sometimes they do that. Yes.
Mute yourself. You are distracting the class.
Hello, can you hear me now?
Yes, sir, we
Yes,
can
sir.
hear you.
Yes, sir.
MTN was misbehaving. So I don't know where I stopped now. Anyway, I was trying.
You were saying we should read the part 3 very well, although it's also
I said the reason why you have to classify the dispute is because connecting factors are not the same for every class of dispute. So if you do not know the subject area that a dispute falls, you will not be able to get the connecting factor to determine applicable law. And I said that the presenters have made some fair attempts on broadly discussing connecting factors across subject area. But for you as a conflict of law person, you must know that the real skill is in characterizing the issues. Because if you cannot understand the category into which a dispute falls, it will be very difficult for you to know the connecting factor that you want to use. So they gave examples. If a dispute falls into the subject area known as tort, okay, that is an act or omission type of dispute. The crucial connecting factor then will be where did this happen? So, and that test is expressed in the Latin maxim, lex loci delicti commissi, law of the place of the tort, or law of the place of the delict. Okay? More detail of this will be discussed when we get to choice of tort laws. Then, if you are talking about marriage, you want to nullify a marriage. Here, we distinguish between capacity and form. If you want to nullify a marriage on the ground of form, a Nigerian court will apply lex loci celebrationis. Looking at your pleading, we will try to see where you said the formal ceremony of the marriage took place. So that is the law we will try to apply, so that in order to determine whether to declare the marriage a nullity or not, we will be guided by the law of the place where the marriage was celebrated. On the other hand, if it's a question of capacity, such as age, capacity to consummate, prohibited limit of consanguinity, prohibited limit of affinity, whether previous marriage was in existence when this particular one was done, etc., etc. In all of these cases, we apply lex domicili, the law of the place of domicile. In some countries, they will apply lex patria, the law of place of nationality. Okay, but we apply law of the place of domicile. When we get to conflict of marriage laws, you will see that domicile is capable of two meanings: matrimonial home domicile or dual domicile. When we get there, we look at the difference between the two. But for this particular class, it is good if you understand that capacity to marry is governed by law of domicile. Okay? Then inheritance. Inheritance will depend on what is being inherited. If you are inheriting movables, status is not important. The reason is that conflict of laws consider that personal property can always be removed. It's not fixed in a place. So when you are talking about who has a right to inherit another person's a disease movable, we will apply the law of the last place of domicile of the disease. Okay, but if you are talking about immovables, because the principle is that the country where the movable is situated has a role to play in the matter, we will say you apply lex situs. Okay? Then wills. If you are talking about validity of a will, you have several options. Are you going to use the law of the forum? Say, well, I'm in Nigerian court. What does Nigerian law say about this type of will? There's some strict requirement of English wills, which we have inherited. And the person is saying, oh, why are you going to apply Nigerian law? I'm not domiciled in Nigeria now. And I didn't make this will in Nigeria. So all of those factors become relevant. Which is the connecting factor? The connecting factor for validity of will generally is the law of the place of domicile of the testator. Okay? It's law of the place of domicile of the testator. Then you have issues arising from contractual or related relationship. Our conflict of laws take the position that because parties were exercising their freedom to agree, that freedom will include freedom to agree on the law to govern their agreement. So what we want to do, if we have to resolve disputes arising from contract, is to find out the intendment of the parties. So we call our test proper law of the contract. Proper law of the contract, by which we mean what the parties actually intended, what the intention the parties actually express as regard governing law, failing which we imply one from what they express, failing which we use the test of the law with the most significant connection. We look at the different contacts and see which one has more of the quality contacts. And we say that that is the country's law that we will use to govern the issue. So all of these, they arise because there is a foreign element and two or more countries are involved and their laws are not the same. When their laws are the same, as we learn when we move on, parties may not necessarily plead foreign law. If they do not plead foreign law, you do not throw the case away to say this contract was done in Kenya. Nobody has given us what Kenyan law says about it. No, what you do is you apply Nigerian law if they are in Nigerian court on the assumption that, well, if Kenyan law had favored any of the parties, it would have pleaded and proven it. Failure to plead and prove Kenyan law simply means that they are telling us that it's not in any way different from Nigerian law. So instead of you to throw their case away, you apply Nigerian law. Good evening. How are you? So these are the simplest of technique issue. Okay. Do we have any question? Can you successfully link characterization with connecting factors in order to determine applicable law, so that you will not make the common mistake of people who don't know this subject area, who would assume that jurisdiction means the same thing as law. Those who don't know this area will usually assume that jurisdiction means the same thing as law, and they will apply what ought to be connecting factor for law to determine jurisdiction. Okay? Sometimes they will apply what ought to be connecting factor for jurisdiction to determine applicable law. That is not correct. The question of jurisdiction is different from the question of law. The fact that a case is going on in your country's court does not mean that your country's law, internal law, will have to be applied. Okay, on the contrary, the aspect of your country's law that will apply is our conflict rules. And it is our conflict rules that will determine governing or applicable law, which may end up not being your country's law. Okay, and at the end, it is your country's law that is being applied, but it is a special aspect of it. It's conflict rules that is being applied to arrive at an answer. Okay? So, I think that is all we need to explain in this first stage. In this first stage, next week, since the writers have undertaken to redo their paper to cover topics that they have not mentioned, they will talk to us about what Maurice calls technical problems. In actual fact, most conflict of laws textbooks will not discuss what I want them to treat next week at the beginning pages, because they don't want to confuse you. Okay? But they will now do so towards the tail end They will do so towards the tail end, and they call it some technical problems. Okay? So that's what we want to look at next week. But you need the foundation of this one to be able to benefit from next week's lecture. Okay, there are 4 technical problems that we normally discuss. The first one is, we have talked about characterization, but the one we talk about is the simple characterization. You are not confused. You know by what law you are going to categorize. If the case is going on in Nigeria, you categorize by Nigerian law, okay? But there are a few instances when that will not work. There are a few instances when that will not work, and there are options that legal writers have given that, okay, do it like this if it doesn't work like that. And those options have been compared and criticized. Then we have what we call RUVA. Okay.
My friend.
Then we have the one we call incidental question. And then we have what we call time factor. Laws do change. Okay. Suppose in between the time, suppose it is an event issue. And in between the event and the time of filing action in your own court, in your own country's court, the law of the place of the event has changed. So what do we do? That's time factor. Which one do you apply? Do you insist on applying the law as it was when the event occurred? Or do you apply the law as it is presently in the locus delicti? So that's time factor. We have incidental question. You take a succession matter to court. It turned out that applying the law of statewide to the succession issue will not solve your problem because there's another issue. That issue is the incidental issue. Maybe the question of marriage. Maybe we are trying to see whether we are trying to arrive at who is entitled to inherit a deceased immovable property. And we have applied the law of the last place of domicile of the deceased. And we have gotten who is qualified to inherit. But there is a knotty issue, which is the issue of A, B, or C are qualified to marry, depending on the marriage of D, whether there was a valid marriage to D. Just like the case of Fonseca and Passman. Marriage was an incidental question in Fonseca and Passman. The real issue was inheritance. The children of the marriage, the question was whether they were entitled to inherit the deceased assets. And all of a sudden, it became necessary to determine whether their mother was validly married to him. So marriage was an incidental question in that case. The principal question was inheritance. So you sometimes have incidental question and you are confronted with options. Okay, you are confronted with options. What are those options? And what is the attitude of common law jurisdictions to the exercise of those options? Is what we are going to look at incidental question. Then RUVA, research conflict rules of the forum will direct us as regards applicable law. Suppose the applicable law is the law of state Y. There could be a further question. What law of state Y? Is it the internal law of state Y? Or is it the conflict rules of state Y? Okay? Just like as we were explaining, we said at the end of the day, it is the law of the forum that is applied. But if the matter has a foreign element, you apply the conflict rules. If it has no foreign element, you apply the internal law. So if you apply the conflict rules, and the conflict rules direct you to a less COSIA, a foreign law, okay? What is the meaning of foreign law in that context? Because just like the forum has two lines of laws, its internal law and its conflict rules, the local COSIA will also have two, its internal law and its conflict rules. So there are occasions when that Lex Corsia will be seen as the conflict rules of the Lex Corsia. And there are occasions when that Lex Corsia will be seen as the internal law of the Lex Corsia. That is what the Ruval concept addresses. Okay? So those are the four technical problems. We do not dabble into them until we have understood the simple one. Okay? So what we expect our colleagues to tell us is the meaning of each of those technical terms, their implication, and our own approach to it. Countries may have different approach. A country, for example, when you come to Ruva, may say that, look, whenever our company rules direct us at the law of statewide, we apply the internal law of statewide. When they say that, we say they have rejected Ruva. Okay? Another country may say, no, it is their conflict rule we apply. If they say it is their conflict rule, then you have another joint. You have single Ruva and double Ruva. Okay? So next week, when they are talking to us about Ruva, they will not only tell us the differences between the different Ruva categories, they will tell us what is our own position. When we say our own position, Nigeria does not usually have any position different from England. So they will look at English cases and say, English cases and English textbook and say, this is what the English cases and English textbook say the English courts should do in rural circumstances. So I think on that note, my inverter is already making noise. I think on that note, I've said the much we want to say today. We see ourselves next week. Let our next week lecture be physical, please.
All right, sir.
Thank you, sir. All right, sir.
Yeah.
Thank you, sir.
Okay, welcome. Oríire kí ni? Ìdánwò tó ṣe, kí ló ṣẹlẹ̀ ń pa ẹ̀? A dúpẹ́ lọ́wọ́ Ọlọ́run o. Àbí?